Hello and welcome. You're watching CNN News 18. I'm Avantika Singh. Well, big news coming in. The Supreme Court has ruled by majority that sub-classification within the scheduled caste and the scheduled tribes is permissible. So this is a big judgment that has come in. In fact, it's a 7-judge bench of the Supreme Court that has pronounced the judgment on the permissibility of sub-classifications within the SC/ST. In fact, arguments had been going on if sub-classification is in fact permissible. Now, let's just tell our viewers as to why exactly this was needed while addressing, it's most important for addressing inequalities and most importantly to address disproportionate representation. But let me go straight across now to Ananya for more of this. Ananya, first of all, tell us a little bit more about the 7-judge bench judgment. It's a big one. And, what does it really mean and what was the purpose of this case to be heard by the 7-judge bench?
It was a 5-judges bench verdict, which was actually, challenged before a 7-judges bench of the Supreme Court. The Supreme Court felt that there is some kind of a lacuna in law, there is something, a position of law that needs to be cleared, and hence a matter was referred to a 7-judges bench, which is headed by the Chief Justice of India, Dr. Justice Gawai himself, which is now, with the majority of the majority opinion holds that in fact the sub categorization or the sub classification of in fact the SCs and ST or the reserved categories is something that can be permissible. It also goes on to say that the Article 341 and 342 they do not talk about the number of seats of reservation, but they talk about the identification of the scheduled caste and scheduled tribe, and there is no friction in law with regards to whether or not sub-classification can be allowed. Very categorically, this is the majority of opinion that has come in from the bench headed by Dr. Justice Gawai Chandrachud. But there is a dissenting opinion of Justice Bela Trivedi as well. So we'll have to wait and watch for that since the pronouncement is still going on. They are giving a conquering opinion on the side.
Okay, I'll just go back. So the big news is that sub-classification is now permissible within scheduled castes to give separate quotas for the most deprived, for the more backwards. Ananya, if you can hear me clearly, I wanted to ask you what is going to be, the socio-economic implications of such sub-classification and how will they be able to discriminate the weakest out of the weak? Like, how is that going to be done?
Well, definitely, this is something that needs to be carried. That is exercise that needs to be carried out by, in fact, the on the orders of the president, and also then by the various states in the country. That is with regards to Article 341 and 342 of the Constitution of India. And very categorically, this is one thing, a very very interesting case where the central government is also, in somewhere or the other in support of a sub-classification. And that's exactly how, the Attorney General of India, Mr. Venkat Ramani, and also the Solicitor General of India, Mr. Tushar Mehta, had argued that, there can be more disadvantaged among the disadvantaged already. So that is exactly, the rationale that has been taken by the Supreme Court. The pronouncement is still going on. So we'll have to wait and watch for the full pronouncement to complete. And in fact, the most important part would be, in fact, the dissent that Justice Bela Trivedi has actually penned in this particular case.
Now, tell us a little bit more about this case. Why was it taken up in the Supreme Court? Okay, I'll just come back to you, Ananya, but this is a big one coming in on the sub-classification of the reserve class. A big judgment coming in from the Supreme Court. We're going to shift focus now to another big news. It has been